Welcome to another episode of Scholarly Soundbite. Today with us we have for our guest feature Dr. Ashit Kumar Srivastava, who is currently an assistant professor of law at Dharmashastra National Law University, Jabalpur. Sir has worked in different areas and has completed his PhD in data protection law from National Law University, Orissa, and has done his master's in constitutional law from the Rajiv Gandhi National Law Institute or Law University of Law in Patiala. Beyond his correct position, he also has teaching experiences in National Law University, Odisha, and formerly in Amity Law School, Lucknow, as well. His work spans different areas, which are very interesting, and I'm pretty sure our listeners and guests would be very interesting to have a conversation with about. This involves, for his work, involves constitutional law, administrative law, data protection law, and he's also committed to giving back by volunteering to train and teach students in the evolving areas of data protection law. We're very honored to have him on board with us for this episode. Sir, thank you so much to providing your valuable insights for all the listeners and viewers.
Thank you so much, Kaushik. The pleasure is all mine. Thank you so much for inviting me for this platform. Thank you.
Thank you, sir. So, just before we just go into the entire crux of how you have done your work and what research you've done, let's just hear a bit about yourself, sir, from you.
Yes.
I have not discussed a huge bunch, so could you just tell us a bit about your work, your interests, and what you're currently interested in doing?
I'm teaching. I teach constitutional law. Data protection is a forte which I enjoined from 2019 onwards. And since then onwards, I've been working upon constitutional law and data protection law. On and off, I also teach law and technology also, and I offer courses on AI as well. So I think for the last 5 years I've worked upon data protection, but primarily for last 8 years I've been working in the field of constitutional law. So that has helped me a lot actually in my research work also, both on the subject of constitutional law as well as in the field of data protection law. Uh, I, as a researcher, I primarily feel that I want to innovate a lot because though constitution is a very large subject, but it's not possible for me to gain every set of knowledge. But in between, I try to come up with new set of ideas. So I like to find myself in a more of a constitutional scientist, which gives me a lot of peace when I think about myself in that manner, and that gives me a lot of peace that yes, even if I am not able to get everything as a knowledge from constitutional law, it's not easy to get everything, every knowledge of a constitutional law. But at the end of the day, if I am able to call myself as a constitutional scientist, that gives me a peace that yes, even if I am not attained everything, but I am still on the way of attaining something.
So definitely, I think, sir, your background has a lot of different things that you worked on. Even when I was going through your research work, I saw that you've authored a lot of papers in different domains, and we'll have a lot of interesting insights when we are discussing them. So in this first section, we are going to talk a bit about personal data protection and data protection laws because it's a very relevant topic today in the world. And you've seen that India has had so much of a flux with regards to data protection laws and so many debates about data localization and India's utilization of data and cross-border data protection. So, in your opinion, sir, where does this debate currently stand, and how do you think this potentially impacts India currently and the citizens in the country?
Right. So primarily, the whole agenda of data protection is works upon competing value system. This whole idea originated in the European context, the European Economic Zone, which is what we normally call as European Union. They had this idea of safeguarding the personal data, or what we normally call as digital dignity of an individual. So while doing so, they realized that while they are safeguarding digital dignity, there is a good amount of competing value of the business people also who want to process the personal data. So that led to the creation of the GDPR, basically the General Data Protection Regulation. This is not the first regulation which European Union has. They already had Data Protection Directive in 1995, and even prior to that, they had so many cases upon the concept of personal data and the idea of human dignity that they already has some kind of essence of personal data always flowing under their floors. However, as this concept got much more globalized, now people across, I think, more than 120 countries now recognize or somewhat recognize the concept of personal data. India too is one of those countries which is doing so. Primarily because after this 2016 Cambridge Analytical case, everyone realized that how important the concept of personal data is to one individual, and this ownership concept got much more hype. That yes, everyone has some kind of property interest in their personal data. Something which I think, as an Indian audience, let alone we do not respect privacy of an individual. To respect the concept of personal data is another level to go at. It's more advanced knowledge because we don't respect each other's privacy at all. So, so just to imagine, to respect personal data is a different forte altogether. Howsoever, this got proportionally hyped because of the Cambridge Analytica scenario. People realize that how important their personal data can be, and they are foreign corporations and companies which are ready to process it at a drop of a hat and then use it again targeting us. Okay, that's one way of doing it. But I think what European jurisprudence did for us is that it created this property value within personal data. Now we realize that there is some amount of property value which I have in my personal data. I can choose this ownership concept. I can choose where it has to go, where it has not to go, whether it can go cross border, whether it cannot go cross border, who can have access, who cannot have access. And just to be clear about this phenomena, this is not the first time that we are discussing this phenomena. This idea of protection of data was there in the Indian jurisprudence or other across the places in some or the other form. Like the whole idea of cybersecurity protection is primarily trying to safeguard your data, but the only difference comes in the form of personal data is that we bring more individual centric approach. So it's in cases of cybersecurity breaches, we are suing in mass breach of data, but in personal data, we are able to find the individual whose data has been breached. Thus, he has much more right upon his own personal data, and thus he can claim for some kind of right compensation against the corporation and company. India did attempt to have some kind of regulation going on for personal data in 2011 when they had the SPDI rules 2011 coming into place, which was also preceded by the 2008 amendment, which when we had section 43A and 72A added in the Information Technology Act 2000, which provided an essence of personal data, but at least if someone's personal data was infringed by a company, he can claim for compensation. And there were few cases which happened at that time also that created some amount of proprietary interest in the personal data. But then this got much more consolidated and much more streamlined by the KS Puttaswamy 1 and KS Puttaswamy 2, which brought so much jurisprudence. I think this is we lacked legal literature. We lacked legal literature. There was no legal literature upon which we can base and say, "Oh, I have a property interest in my personal data." And I think legal literature plays such a remarkable role. People have been, at least in India, they have not been able to appreciate legal literature that much. We are so hyped with the idea of litigation going into corporate, but we tend to forget the phenomena who will write the legal literature upon which we'll base our arguments. If there is no legal literature, how are you basing your argument upon something? Like you require some amount of some, I didn't say some modicum amount of literature upon which you can base your arguments. Who will write that? And that's the irony of Indian academia as well, which I'll get to you later on. This happened in this personal data protection field. We had no literature. How will we grow this jurisprudence of personal data? This is an irony. Yeah. So this all changed by 2017, 2018. Case Puttaswamy 1, case Puttaswamy 2. Justice Sanjay Kishon Kaul delivered a beautiful judgment. Honorable Justice Justice Sanjay Kishan Kaul delivered a beautiful judgment in the case of Swami 1. He wrote a 49-page judgment, and that judgment was so remarkable that made me moved, actually. That made me rethink how personal data really works. And that judgment was remarkable. That led to this creation. Then yes, gradually we started developing our own field. In 2018, when we had case Swami 2, this question was even raised by Supreme Court of India, asking the central government, do we have any kind of legislature in the field of personal data? To which central government had replied that we have made a committee of retired Justice Shri Krishna Committee ji to come up with a bill, and that bill came out. The bill was a very good foundation for the personal data protection. In fact, the whole of the around 250 plus pages the report submitted by Shri Krishna Committee ji, and that report was marvelous. That had dealt with all the aspect of personal data, including the European perspective, American perspective, Chinese perspectives. Beautiful, beautiful committee report. But gradually, I think what we started with 2018 and what we have in 2023, there are some amount of trimming which has been done to a large extent. Our personal data jurisprudence, as at least what was initiated by the Sri Krishna Committee report, was very exhaustive. Like it was dealing with every set of obligation, every set of rights, every set of framework which was required. But by 2023, when we came to this new enactment, it has been trimmed to a large extent. And I won't say it is been trimmed without a cause. There is a cause for which they have trimmed this also, but I think I'll discuss that as we go on with this discussion.
So you've already done so much of work in personal data protection, and it's very interesting for our listeners also to understand about these different aspects that you discuss. Right? I think this is sort of like encapsulated by your own publication. You've written a book very recently on personal data protection rights, and this authored book has a lot of different nuances which delve deep into this. Yes, as Sir is also showing to a lot of our viewers, we'll link it down in the description as well. You can access Sir's books there. But this entire concept of personal data, how would you see this book in the market today? How do you think this addresses a lot of issues? Because we have this discussion around Internet of Things and other ideas of how your personal data is consumed by assistants and other people, like smart home assistants and other smart devices. So there's so much conversation points which come around from personal data. So you've written very deeply on this. So what led you towards writing this book? What gave you the motivation, and how do you think this contributes to the existing literature?
This was more of an organic interest which I have grown into this. Uh, though I was little digressed in the initial phases as to what should I research upon, but I always had this in mind that if I get a topic of my own liking, I'm gonna go all 100% in. And I think I was by God grace and by guidance by few of the professors in my field, I have been I got the right direction. Right. So as you talk about the phenomenon, I think I can summarize what you said is in a more of a that we live in a very information centric society today, and every device, every software, every hardware which we are living in, be it Internet of Things, be it the CCTV when I enter my office, or be it the smartwatch which I am wearing, which I'm not wearing right now. Everything and every, or even my mobile phone, the biggest culprit in this case. Anything and everything is collecting so much of my data all the time. This led me to ask this question because the fundamentals of the data protection was quite established by 2016, and this is just not about a GDPR. OECD again, a big organization globally also, which deals with the idea of corporate and as the idea of external trade across the globe. They had also issued guidelines regarding. There were fundamentally seven principles to govern the concept of about personal data, and this was they were quite famous at that time. That made me think a lot that how are these principles to be imbibed within Indian context. And gradually, I think that one question led to the other, and now I realize that how like we're still at the baby steps to understand even what is personal data. Like this is the first thing which even Europe took 20 years to explore what is personal data. So just imagine that then they took 20 years to understand what is personal data, then they were able to establish all this establishment and infrastructure to enforce the right. For us, we have started what is personal data in 2023. So it's going to take at least take 10 years to understand the wide scope of what is personal data. Uh, I I asked this question to my students: do you believe that is your answer sheet your personal data when you write an answer in the exam? To again, this is just one aspect of it. Like this is gonna boom to a large extent. And if our data protection board of India, data protection board authority of India, a body which will be established as the ombudsman for the data protection authority in India, if that body per se is more active in this perspective, possibly we're gonna see very revolutionizing cases, like cases I think we have not heard of, like the fact that we are using smart cars today, cars which are capable of having some amount of self-driving modus operandi. They are collecting some amount of data. So this is going to revolutionize the way we understand human relationship in Indian context, because now because for us every relationship is so very social in nature, be it institution as well. Our institutions and our relationships is very social in nature. We never see them in the for the format of a formal authority, or we don't see any kind of formalistic relationship apart from contractual relationship, which normally happens in the cases of mergers or in the cases of enforcement of a contract between two strangers. But when we talk about data protection in the context of institutions, it's gonna change everything per se, because I cannot be seeing my hospital, I cannot be seeing my doctor's clinic in the same way I used to see earlier. I cannot be seeing my CA the same way I used to see him earlier. I cannot be seeing my institution having the CCTV the same way I used to see them earlier. Because now I'm realizing the fact that even they are processing my personal data in some or the other form. Now my relationship with them has just increased tenfolds, and their responsibility towards my personal data has increased 100 times more. So that change of social relationship will be perpetuated by this, and if it is not perpetuated right now, by in the near future, when if we have more penalties being imposed on these relationship, they will surely understand that how it really works.
I think there's a scope of how India operates where you have to sort of like push people to understand things more. So that's also very
Yes.
interesting when you say it in that sense that people need to have those social contracts understood better by those implementation of social laws by the form of say punishment as well, because punishment is a good indicator of how you're sort of like remembering and accessing different information in your life.
No, no, no.
But your book covers such a wide range of topics also.
Yes, sir.
Yes, sir.
Mhm.
You were saying something, sir.
No, no, I was not. I was not. I was not. Yes.
Okay. So I was just mentioning, sir, that your book covers such a wide range of topics, right? Because there are so many chapters. But what do you think should like a reader focus upon primarily? What are the two or three things that are fundamentally very crucial for a reader to look into when they are first accessing your book?
I personally believe. See, the book would be relevant for data fiduciaries first of all. Now, data fiduciary is basically anyone who has the capacity or is basically processing the personal data in this case. So, first of all, there has to be some amount of self-assessment, which even GDPR perpetuates. Self-assessment that what kind of data am I processing? Like right now, even you, while we are having this recorded session, I have given some amount of consent to you that you may use this processing for or personal data for particular academic purposes. Right? So I know that this data is being used for purpose limitation. The purpose limitation is academic, or even to make bring awareness to the people at large. So even our relationship is getting governed by this principle right now. So I think there has to be some amount of self assessment by some of the institutions, the way they have been acting or they have been working. They have to understand that their responsibility is increasing, because something which we have lacked for 20, 30 years in this jurisprudence, because we never understood, we never asked about some person. Oh, if, even if I am a if I am a I'm a doctor's clinic. I just took some data, I put it on an Excel sheet, and I shared it with few other doctors. And then someone started receiving spam calls regarding medicine. Oh, right. Now the problem is that we never set the boundary, and I think this is more Indian to us. We are very sociological persons. We tend to be more upon the sociological aspect of it. Oh, I know him. He knows me good enough, and that's a contrasting relationship with the European Union has, which is more of an individual society, which works more upon the legal relationship, which as compared to social relationship of Indian society. Thus, so we are trying to bring that kind of relationship within the Indian context, where now when if you're a stranger to each other, I'll be asking you questions and why did you keep my data? So there's so if you, someone is going through this book, the first thing I recommend all of you is read about data fiduciary. Try finding out a self assessment that whether are you one a data fiduciary or not. If you are one, then there are certain technical and organizational management which you have to ensure that the data is secure. That's one set of idea. Second thing I'll recommend everyone, if you're there reading this book, is do read about your rights. The title of the book per se is personal data protection rights, and I think this is something we want to create. We want to create a culture of data protection right, that people are so well equipped. Oh, you know what, I had given my data to Facebook 10 years back. Now I need to ask them to delete this information. And if they're still processing it, why are they processing it? So all so just to be aware, and my book covers a lot many case studies, and even some case study in the Indian context, that how in those situations how would one should react in a situation like that. Possibly drawing a parallel as to what happened in the European context, but not completely, but to a certain extent. So you understand the phenomena that self-assessment is one aspect I think I want to highlight. Second aspect is the idea of the protection of the rights the person should be equipped with. Third is the grievance redressal, that now when we have a self-assessment, now that we have rights, what are the mechanisms of readdressing those grievances? And that will demand more role on the front of the data fiduciary, that he has to create accessibility of grievance redressal to the data principle, which is us basically, that we are easily able to apply our rights also. So I think these are the three aspects I really want to highlight. If someone is going through this book, do a self-assessment, be equipped with your rights, and be equipped that yes, you have a grievance reversal which you can easily apply also. And I think that will surely lay down a pathway for us in the near future, because again, it's a growing jurisprudence. It's going to grow more, and I personally believe the first 5 years are going to be most tricky years for the personal data protection, because even today, not today, including me for that very perspective, a lot of us do not know what can come within this norm of personal data. It's just so large. We might not be able to just come out what really personal data is. For example, right now I'm sitting with you right now. Do you believe that what okay, apart from my gesture, apart from my talking, about my what other personal data can you take out from my background, from my speech, even what I'm wearing in my hands as a wristband? Everything will qualify as well. So that amount of, I think, that will come if you one goes through this book for sure.
Definitely. I think there are a couple of interesting conversations that happens with AI tools and AI models also right now. Because we have seen that technology has become so that if you're placing
Yes.
a picture on an AI tool, you can just geolocate that person as well, even indoors or outdoors.
Ah,
So this conversation that you're having with
yes.
us as well is becoming
Yes.
very important and predominant in the world today. But this leads to a very interesting
Yes.
perspective. You've done other forms of or other fields of research as well. So one of the things that you have highlighted also is that your approach in terms of AI research. So there's something related to how India is
Mhm.
also approaching AI as well, right? So what do you believe that
Yes.
should be India's primary focus when it comes to talking about artificial intelligence in the context of law, and how does it relate to the broader ecosystem of law?
Right. Thank you. It's a very good question which you asked, Kaushik. I think India is making its stance upon tech. Instead of saying AI, I'll say tech is much more relevant, because we are trying to have that kind of a relationship with AI. India's approach towards tech seems much more liberal, I have to say, in the fact that we are pushing more towards the idea of sectoral regulation and some sort of a very soft law approach. A soft law approach is basically where you do not have a. I'm sorry for this. Right.
That's fine, sir. No problem.
A soft law approach is primarily that we do not have hard laws made by parliament, which might not be very adjustable or very accommodating of the quick changes which we see in tech. A soft law approach, we might be that you have some kind of ombudsman underlying it, and ombudsman is issuing white papers just to have some kind of framework to be there. And Niti Aayog has been doing that for a long period of time. In fact, Niti Aayog is one body in India which has done a lot of research and come up with a lot of white papers upon new tech, be it blockchain, be it cryptocurrencies, be it AI as well. Um, in reference to Indian approach, what I personally feel is, and I've been highlighting this in several of my talks across different platforms. In fact, I'll be also discussing this in one of the summer schools of which I'll be delivering a lecture of in a very in near future, actually, where I'll be discussing this phenomena of the Atmanirbhar Bharat approach. That how India is, because India really wants to make a mark in the startup culture, as well as it wants to boost its economy, at least in parallels with the concept of with China or America. And I don't know if you have seen this, and if I think everyone has seen this now, which is happening, that this this tech Mahakumbh, startup Mahakumbh they had recently in Mahapan. If you have seen this in Delhi, they had this startup Mahakumbh. Yeah, this is basically a initiative of this government which has started in last year, and the second edition happened this year as well, where the minister in charge, Piyush Goyal, had this comparison between the Indian startup vis-a-vis the Chinese startup, and how what Chinese startups are investing in and what Indian startups are investing in. And he highlights, and there were five major areas where Chinese startups were researching upon. The Chinese startup were researching upon the idea of AI, large language model, innovative tools in healthcare, whereas our startups were primarily working in the area of e-commerce, like food delivery apps, or or influencers. So what really struck to my mind was that the fact that our innovation is not primarily working on development of AI per se. We're trying to bridge the gap between the retail and the wholesale through the mechanism of food delivery apps or some kind of delivering of items at your houses. But that will not be called as innovation per se, which is Chinese side is doing, which actually was highlighted very beautifully actually by the minister in charge, Piyush Goyal ji. Oh. And I think this is quite reflective in the governmental stance towards in lawmaking also. If you pick up this Digital Data Protection Act, I am not referring only with this particular act. If you pick up any kind of regulatory framework in India today, mostly upon the tech side, be it AI draft policies or Digital Data Protection Act, or even other laws which are coming in, you'll surely find this common pattern coming in. The Indian approach towards tech is that they are trying to be very liberal. In fact, section number 17, subsection number 2 of this and subsection 3 also of this Digital Personal Data Protection Act quite categorically provides for exemptions to startups from a lot of compliances under this act. So you might not be required to be compliant with notice, even some to a certain extent consent as well, and to a certain extent you might not be required to be compliant with the section number 10, which is again in reference to significant data fiduciary. So and over the top of that, there are certain blanket provision under section number 17 which gives central government the power to notify certain fiduciaries to be completely exempted from the application of this compliance of Digital Personal Data Protection Act. So if I can take out startup from that, if I can take out certain MSMEs which are working in India, just imagine the normal amount of penalty which is imposed in the European Union upon for non-compliance with data protection is way too hefty. In fact, if you pick up CNIL, the one of the most reputed watchdogs of France for data protection compliance, they have been putting hefty penalties upon Google, Meta for decades. Like, and when I say hefty, they're hefty, like euro 5 millions, euro 100 millions, and euro 100. These are hefty penalties. Imagine that kind of compliance requirement for Indian startups and MSME, the micro and small medium enterprises. They won't be able to survive such kind of market, where they for their survival is not that easy. Then compliance with data protection, when data protection is such a dynamic subject, imagine for a small time vendor to not to able comply with this kind of law, and then being penalized for good amount of his budget or of his revenue. Where he will survive? He won't survive. So that's why if you see section number 17, and I have named this in my book also, Atmanirbhar Bharat and exemption clause which we have, that how these exemptions are primarily driven by the agenda of ensuring that our startup culture takes on, it starts running, and it's not overburdened by this kind of compliances as well. So I think Indian approach towards tech, including AI and data protection, is more equivalent or more in sync with the concept of Atmanirbhar Bharat, self-reliant India.
One of the fundamental pushes that even I have observed, sir, for a very long time is that India has this idea about making it easier for small businesses, because I think it needs to also like
Yes.
localize and give
Yeah.
business growth so that jobs also increase in the market as well. I think that's also one of the
Yes.
primary things, that employability and the idea of brain drain not happening becomes very predominant.
Yes.
In the
Yes.
next particular section, sir, we've discussed so many things. You have done so much in your field, but I just hit upon one more topic. There's something some work that you did around jury metrics as well. It seems like a very interesting idea, sir. So, what is essentially is this
Oh,
jury metrics about, and what
अच्छा,
was
अच्छा.
your discussion around this?
The real allocod regarding jury metrics should be given to Sri Gadbois Jr., George Gadbois Jr. George Gadbois Jr. is one of the harbingers in the field of jury metrics. I don't think so at that time when he did his research. His book is quite famous actually. His book is Judges of the Supreme Court 1950 till 1989. I think he's one of the scholars, and he was basically an American journalist, if I'm not wrong, that who undertook this research activity where he interviewed around more than 40 judges of the Indian Supreme Court from the time period of 1950s till 89. And his research is a very viable source of research for what we today can call as jurimetric. Uh, the concept of jurimetric is mostly done on the jurisprudential school of realism, where instead of just reading the law, we are reading about the judges who are delivering the judgments. So we want to know why a judge reacted the way he reacted, what is his pattern of working. So that is a very, well, at least a niche area for India. This is much more explored in the American jurisprudence, where you'll see the work of Roland Dorkin, Richard Posner, and your George Gilbois Jr. How they have critically analyze the way judges react to a particular situation. And that jury matter normally happens by studying their judgments, drawing a pattern, sometimes studying about the judges himself, their socioeconomic conditions, how they grew up, what kind of mindset they have. But you won't find this kind of academic freedom possibly in India. That's not possible to a large extent. In fact, I personally believe this was his only and the last work, which is still referred to a large extent. George Boyce Jr., that judges of the Supreme Court, 1915-89. Uh, his work led to creation of several other books. His work was the inspiration for the work of Shri Abhinav Chandrachud's work on Bombay High Court. If I'm not wrong, I tend to say wrong name in Abhinav Chandrachud sir, but I think it is Abhinav Chandrachud's work on Bombay High Court, which was an inspiration taken largely from the work of George Boyce Jr. Then you have another work done by a great work done by not Sri, Mr. Actually, Mr. Nick Robinson. Nick Robinson did a great amount of work upon this. He studied the constitution bench judgments of Supreme Court of India from 1950s to 2009, 2008 actually. Yeah. So for 58 years, he read all the constitution bench judgments, and he had his whole team been engaged, because it's not possible, not easy that you have to go through all the judgment of the constitution benches from 1950s to 2008. But he did it through his own team, the whole team of people, and that paper is available in the EPW, by the way. If you have access to it, just search Nick Robinson, you'll find it. And for 58 years jurisprudence, he analyzed it, and he came to a conclusion that how most of the time the dissenting ratio percentage of the national average dissenting ratio percentage of the constitutional bench is 8%. I developed my own set of research. I might have taken their pedagogy of research by default, but then I did some more deeper research on the pockets of history of the Indian judicial system, how they react in particular time phases. Like I saw that in around 1975 and 77, the dissenting ratio of the constitutional bench had come down to 0.8%. Oh, sorry, 0.43%. So the national average was 8%, as Nick Robinson tells us, but have been pockets when the executive was much more empowering over the judicial side, and we see a very less number of dissenting ratio coming in. So another work is by our own professor, if you know, Professor Dr. Yogesh Pratap Singh sir, who wrote this book on judicial dissent. This is one of his kind book. I don't think so. People refer to that. I think people know about this book, but they should refer it much more. The book on judicial dissent is a landmark work, because Yogesh Pratap Singh sir has analyzed all the dissenting ratios of the judges of the Supreme Court from 1950s onwards. And I think his very good friend Afroz Alam sir has also written an article upon this, how dissenting ratio comes within the Supreme Court. They have laid down that how there are few judges who tend to react differently. So this idea of jurimetrics is basically going beyond the concept of reading the law the way we see it in the books. It's more about reading the judges, how they behave in a particular manner in particular situations. So it's a very niche area. It will always be a niche area in India, because the only way you will be able to take out a pattern is through reading the judgments a lot.
Definitely, sir. I think that's an interesting idea as well, because I believe that even if, say, for us also, if one of us goes into, if had gone into
Yeah.
judiciary, there would have been a very different inclination because of our social backgrounds and environments. So before we end off and going towards this last
Yes.
section, you have been working so long in academia, you've done research for so long and taught students for so long. What are some of the few takeaways that you have from, say, academic research or academia, and suggesting certain things for people in terms
Yeah.
of how they are going about their research journey?
Oh, it's a very competing interest. It's a very competing interest. I think there's no doubt this is the most noble field I have seen. For a very simple reason. For a very simple reason, I think being a professor, you are at the last frontier to inculcate value into human beings before they enter the market. And I think after this, no one, not individually, they will surely have some kind of value system for themselves while they're practicing as well, or the other elder doing so. But institutionally, I think this is we think professors are the only last frontier in the education system which inculcate value system in the students while before they enter the market. So I take it as a big responsibility for me. I really enjoy this phenomenon. As a researcher and as a teacher, I feel contradicted so many times. Like as a researcher, I want to research more, but then I have classes also, so I want to teach also. So while I'm teaching, and then if I don't feel satisfied, oh, I do not know the answer of this question, and I've been, by God grace, I've been given so many curious students, including you, so many curious students who ask such questions that which are always like mind boggling. Like, why did he ask this question? Why should he ask this question right now? Why? Like as a teacher, as professor, you're setting your boundary, you're setting some kind of authority while you're saying, oh, this refer to this case, refer to this judgment, refer to this paragraph, read about this, and I'm all equipped. But then some asks a very, if the question seems silly, but it's a question to be answered, and I do not know about this. And I'm like, yes, I thought after this lecture I'll just go and do my research back, but this question has perplexed me. Now I have to go back and research upon this question just to answer it tomorrow. So I feel as a researcher and as a teacher, I feel so contradicted all the time. Like half the time I'm trying to take out time for my research. I want to write, I want to write, I want to write. But then I remember I have a class tomorrow, I have to read about that. So I think, I think this is the beauty of the subject. If someone is truly in love with academics, if someone, and I really mean it genuinely, because there are a lot of people who might be doing academics, but the love is still not coming out. Possibly is still not coming out. They might come out one day, but not right now. So I think if someone really loves academics, this is the beauty of it. You teach, and then they ask you silly questions. Not all the time there are silly questions, but those questions will always make your cognitive wheel move, and thus you have to research. And in research, you'll find something new. Then you start writing about that also. I think this is so supplementary and complementary to each other. This I think this is the best. If someone is truly curious in life, academics is the place you should be with all the passion and all the heart.
That's very insightful as well, because I think a lot of students would be inspired by the idea that there is a world beyond corporates, litigations, and judiciary measures as well. Because I think in India also there is a lot of people who have doubts about what academia is actually about and why you go into academia. So this is the last question for you, sir, before we close. In terms of your reference, in terms of how you believe the future will be for personal data, or how academics or research is getting incorporated with AI and other tools, what do you have like in your foresight to think about in terms of these fields, and what would you like to say to the audience before we close out?
Right. In reference to the second question which you asked regarding the AI and the research, basically, I personally believe, and luckily, I was reading about some AI policies right now, just before this podcast started. It was in reference to some journal which I was trying to look into. I personally feel AI is gonna to take over to a large extent as to what we behave or what we work. And I think this is going to be a huge test for us mentally as well, because and even as a personality is a big test for us, because we realize the fact that to be susceptible to the concept that oh, there is an easier way out, let's try that. We might just give in to the last kind of human ingenuity which we have. Like as a human being, what makes us human is that we have this creativity. We are able to create new things. Application of its mind is one aspect. Creativity is, I think, which creates a unique identifier for us. But even if that can be done away with, or if we give in, like I might have a lot of work going on in my life, and then I have this AI tool with me that I can easily use and get an idea quite easily written, even a 4,000, 5,000 page article, and right. So should I resist, or should I give into this lurement? If I give into this lurement, what of me is left is a question. I think this happens all the time. This is not the first time. I think every generation has gone through this in question. Be it when the industrial revolution came out, people used to think, should we buy a car, or should we are happy with going with cycles or walking? And this might not seem a bigger thing, but yes, in the context of social of a generational change, this happens every generation. Something new comes out which will push and ask you question. Oh, why to take the hard way? Why not you just go give in to this learnment? But the problem is, the moment you give in to this learnment, where is you in that learnment? Where do you survive? So till the time you're using AI just to attune your knowledge, just to add something to your knowledge, or even to refine what you have written, it still makes sense. Still makes sense. But if you have replaced your creativity with AI creativity, I think this is we're turning into cattles. We're turning into cattles by default in that case. So this is I'm this is my what my perspective is in reference to your first case regarding so the last question regarding what I want to give say as the last to all the audience which are listening to this podcast. Uh, I feel that at least for the legal academia, there's a lot of potential. Like, and I think even there is some amount of category being created in legal academia that you'll find very elite academicians, you'll find some moderate academicians, and some academicians who are still trying to find out as to what are they trying to do. But if you really have passion, I personally believe if you really have passion, do join this field. This field is enriching. This field gives you a lot of. I think this gives you a lot of reason to get up every day early morning just to prep up for what is going to come up. Yeah? I think this is one field where people like for other jobs you have to have some kind of assessment every year just to update yourself. Oh, we'll have this training session to update ourselves. But I find academia is one field where you do not require such kind of assessment all the time because we know you're being tested every day, at least by 120 or 60 students every day who are asking you some of the other questions. So we know this field is so enriching, and if you have a taste for knowledge, oh, then I think this is the right field for you. Uh, I think this is what I want to give to give everyone. If you have a taste of knowledge, I think legal academia or academia is per se is the field where one wants to be.
Thank you so much, sir. That was pretty valuable insights throughout the episode. I think the listeners and viewers will get a lot of ideas about different fields in terms of personal data, academia, and researching as well from your thoughts. Again, thank you so much for coming on board with us. We hope to have you again soon.
So thank you so much, Kaushik, for being patient with me. I know this hasn't come very quite easy actually, and I'm really thankful to you for for sticking around and getting it done today itself. Thank you so much for doing this, and hopefully, we'll near future we'll have more session like this, and we'll meet soon physically as well.
Definitely, sir. Definitely. It's been a long time since we have spoken.